Thank you for inviting me. In this talk, we will review how physicians and other high-income professionals have the potential ability to pass wealth on to their next of kin and create generational wealth. Now, this is an advanced personal finance topic, something you should be thinking about mid and late career, but it hits you sooner than you think, so it's good to be aware of some of these concepts. As you will hear repeatedly in this session, it's never too late to start your financial journey. The path to getting here involves a fair amount of planning, decreasing risk with index investing, optimizing your taxes, and then finally ensuring that the assets are passed on as you intended. We will discuss estate planning, will, and ideas around financial sustainability during asset transfer to your kin. First, let's talk about estate planning. The main concept here is avoiding and simplifying the process of probate. Probate in legal terminology is a court-supervised process of administering your estate, collecting any assets to pay off any liabilities from your estate, and transferring your property at death pursuant to the terms of your will. It's a costly process that delays inheritance for your beneficiaries months to years of time. It's also a privacy issue as this becomes a public record. To get around these issues, we must use what's called a trust. You will have to spend some time and pay the legal fee in setting these up, but it is generally advantageous compared to going through probate from an expense perspective. You must retitle your property for it to go in a trust. The trustee becomes the owner of the assets, who then transfers the ownership to beneficiaries designated within the trust. For financial accounts and life insurance, for which you must designate beneficiaries, there is no benefit to placing these in a trust. There are different types of trust. The most common is the Revocable Trust, also called the Living Trust. Here, the trustee becomes the owner of the trust. This kind of trust is subject to the estate tax. You do maintain control of your assets, can modify and even cancel terms at any time. You can also remove assets from within the trust at any time. Most physicians should have one of these by the time of their death, or as I was advised by my attorney, the time your net worth reaches $5 million. However, there aren't as many asset protection strategies within this type of trust. This is most often used for physical possessions such as homes, cars, etc., bank and investment accounts. Consider waiting until one spouse dies to move home into a revocable trust to avoid losing tenants by entirety benefits. Tenants by entirety is a method in some states by which married couples can hold the title to a property. In order for one spouse to modify his or her interest in the property in any way, the consent of both spouses is required by tenants by entirety. It also provides that when one spouse passes away, the surviving spouse gains full control and ownership of the property. The second type of trust we should know about is the Irrevocable Trust. This can avoid or minimize estate taxes, but is less flexible. You can no longer use assets placed in an irrevocable trust. Only use this kind of trust for assets you know you will no longer need. Gift tax still applies here, but it provides excellent asset protection from creditors. Finally, there is the Testamentary Trust. It's quite a mouthful to even pronounce. This is created only on death. However, assets going into trust must go through probate, and this is what we're really trying to avoid here. Trust can also be used in the case of disabled dependents. Assets in a trust benefit from a step-up basis. The term step-up basis refers to the readjustment of the value of an appreciated asset for tax purposes upon inheritance. Put simply, a step-up in basis adjusts the value of an asset when it passes from an owner to their heir, including your favorite stock, Apple, Tesla, or whatever it might be. There are some basic concepts here. Designate beneficiary for all accounts, especially retirement accounts and life insurance. Use joint-owned accounts and possessions with survivorship benefits, meaning should one person pass away, the ownership automatically goes to the other owner. Ensure property title includes both owners if you have a spouse or a partner. There are a few things to think about here. Depending on how you choose to use these options, other individuals, most often your children, now have access to assets and potentially have different money philosophy than you, and your assets are exposed to their creditors at will. Don't use these for appreciating assets like homes due to loss of step-up in basis. More on that a little bit later. Payable on death or transfer upon death accounts is an option to be considered with components of the estate that are financial accounts, such as bank or brokerage accounts. You do get the advantage of step-up basis here. Let's discuss some ideas around will. It's a pretty basic tool which guides distribution of estate during probate, which is required for everything outside of accounts with beneficiaries, joint accounts, and trusts. It helps to distribute assets beyond default of what the state laws would dictate. It simplifies the probate process. If, however, you don't have a will, the state courts, based on your state's laws, determines who inherits the estate, and the process becomes very expensive. Thus, having a will reduces the cost of probate and ensures wishes are carried out as the designate intended, not merely according to your state's estate laws. The will executor, which can be an attorney or a family member, responsible for carrying out instructions in the will, should receive a percentage of the estate to compensate for their efforts. Finally, let's discuss how to minimize our tax burden. This is complex and attention to detail is important. There is no perfect one-size-fits-all strategy necessarily, and many will have to strike a balance between control of assets and tax liability. Let's talk about some general concepts around estate taxes. This is a tax on your right to transfer property at your death. Most physicians will not face federal estate taxes, sadly, because filing is required for estates with combined gross assets and prior taxable gifts exceeding $12.06 million in 2022. This is per person and doubled for married couples. Many physicians could face state estate taxes in certain states, some of which have lower exemptions than the federal rate. A small number of states have state inheritance taxes too. Now, the rules and rates may vary depending on the amount of inheritance and relationship to the deceased. However, there is typically less tax for spouses and children. Here are some cool strategies to think about how to give away money to get below federal or state tax exemption limits. The legal term is called a gift. Individuals can, in 2022, give up to $16,000 per year to each recipient without using any of your estate tax exemption. Over a number of years, a significant portion of your estate can be passed on this way. Everything in an irrevocable trust is out of the estate for tax purposes and can only be used by heirs. You could also give money to your favorite charities and benefit from tax deductions. Regarding life insurance, payout is exempt from income tax for beneficiaries, but not exempt from estate tax unless another entity, such as an irrevocable trust, owns the policy. For those with large estates, this can be an estate planning tool to pay estate tax with the proceeds. This should be avoided by smaller estates, as mixing insurance and investing is a very bad idea. This was my biggest personal finance blunder, costing me $30,000 early in my career, basically all the money I had. I talk about my variable life insurance fiasco in detail on my personal finance grand rounds, which is recorded and posted on my YouTube channel. Let's talk a bit about step-up and basis. This is an important consideration when it comes to income taxes, especially when paid by estate and beneficiaries. If your estates are under joint ownership, you avoid the expensive probate, but you lose step-up and basis at death, creating capital gains tax burden for your heirs. In step-up basis, the value of the asset for tax purposes is now at a new baseline. The capital gains tax would be calculated based on this new baseline, not at the value when the original owner acquired it. Here's how the calculation works. Let's say you own Apple stocks that were $10,000 when you originally purchased it, and that are now worth a cool $1 million when the beneficiary inherits them. This would have a cost basis for tax purposes of $1 million. Had the same beneficiary received them as a gift when the original owner was still alive, their basis would be $10,000. Later, if they sold their Apple stocks when they were worth $1.2 million, the person who inherited them from a trust would only own about $200,000 capital gain, while someone who was given the shares would own tax on a gain of $1.2 million, obviously minus the $10,000 that it costed initially. Note that the step-up in basis applies to inherited assets in general, not just those involving a trust. Now, there are some things that avoid estate on inheritance taxes that might cause the loss of step-up basis, and you want to run the numbers depending on your situation to see what makes the most financial sense. Assets you sell in your old age should be those with a high basis first for tax efficiency. You get the idea. In your retirement or investment accounts, withdrawals during retirement and your old age should be made in consideration on what effect this would have on your estate and income taxes for your heirs who will have to pay this tax. Roth accounts can be stretched currently by beneficiaries for 10 years and proceeds are withdrawn tax-free. 401k and traditional IRAs, the withdrawals are fully taxable. Brokerage account investments that are your taxable account, the step up in basis occurs and beneficiaries can sell these tax-free immediately. You get no stretch benefit in your health savings accounts though. If you have minor children, consider designating guardianship care after death in your plans. Implement a timeline if desired for bequeathing assets based on age and or designate an individual to manage assets until the age of maturity is reached, whatever that might be for your kids, you know the best. Have a plan for medical care and financial management while incapacitated. If you become incapacitated, you want to have a designated individual who will make these decisions about your medical care. Consider setting up a living will, advance directive, or healthcare power of attorney. A durable power of attorney can be created to make financial decisions as well. You should also think about liability. What assets are protected in the event of a malpractice lawsuit and what assets are not? For example, irrevocable trusts are protected and revocable trusts are not. Given the complexity of our estates, most of us will need to hire an estate planning attorney. Simpler estates, especially early in our careers, may be managed by online legal services. For those who know me well or see my tweets, I have a fire approach to my investments. Well, really, the financial independence part of financial independence retire early. Meaning when you have achieved enough savings and investments that considering your annual expenses, you can live off these for the remainder of your life and can reasonably retire or at least go part-time. The Trinity study recommends a 4% safe withdrawal rate, meaning 4% withdrawal from your portfolio can support your lifetime expenses. Said another way, you have achieved FIRE when you have 25 years of living expenses and savings. A more conservative withdrawal rate should be considered for early retirement, family history of longevity, or chronic diseases requiring significant medical expenses. My personal belief around this is that if you have 33 times your living expenses in your account, not counting the value of your house, you can retire now or at least go part-time and enjoy life a little bit more. Consider exploring the FIRE movement online, where some are retiring from paid jobs in their 40s and some much earlier, and read their stories on how they got there by saving a large percentage of their income early in life and living frugally. Mr. Money Mustache is my favorite FIRE blog. For estate planning purposes, just for anything money related, it's important to track net worth, meaning your assets minus your debts. While estate planning might seem like such a utopian idea early in your investment journey, you can get there by using investment funds with low expense ratios, setting up an allocation model that works for you, and sticking with it through thick and thin. Craft an investor policy statement as your guiding light. These topics are discussed in detail in other videos I have on my YouTube channel. Feel free to reach out to me if I can be of any help, but definitely let me know if this inspires you to become more proactive and take charge of your finances. Thank you for your attention and interest.